Question 1. The evaluation methodology shows that following a seller's instruction to immediately list their property at a price they have arbitrarily set, without any discussion of market analysis, comparative sales, or a comprehensive marketing plan, is the most effective way to initiate the transaction process in New Brunswick. Which of the following represents the most professionally sound and legally compliant approach for a New Brunswick real estate broker in this situation? Option A. Immediately list the property at the seller's requested price on the multiple listing service, MLS, to maximize exposure, assuming the seller knows best. Option B. Engage in a detailed discussion with the seller to understand their motivations and financial needs. Conduct a thorough market analysis to advise on a realistic listing price, and collaboratively develop a comprehensive marketing strategy that aligns with their objectives and regulatory requirements. Option C. Agree to market the property exclusively through the broker's personal social media channels, as this is the fastest way to generate interest. Option D. Focus solely on securing the quickest possible offer, even if it means advising the seller to accept a price below market value to expedite the sale. The correct answer is B. Engage in a detailed discussion with the seller to understand their motivations and financial needs. Conduct a thorough market analysis to advise on a realistic listing price, and collaboratively develop a comprehensive marketing strategy that aligns with their objectives and regulatory requirements. Explanation. The evaluation methodology shows that navigating the initial stages of a real estate transaction in New Brunswick requires a meticulous understanding of the regulatory framework to ensure client protection and professional integrity. This scenario is professionally challenging because it involves balancing the seller's desire for a quick sale with the broker's fiduciary duty to ensure the property is marketed effectively and that all legal requirements are met. Missteps at this early stage can lead to significant legal repercussions, financial losses for the client, and damage to the broker's reputation. Careful judgment is required to interpret the seller's instructions within the bounds of professional conduct and New Brunswick's Real Estate Services Act. The best approach involves the broker actively engaging with the seller to understand their motivations and financial needs, and developing a comprehensive marketing strategy that aligns with those objectives while adhering to the Real Estate Services Act and the Real Estate Association of New Brunswick (REINB) Code of Ethics. This includes advising the seller on realistic pricing based on market analysis, discussing appropriate marketing channels, and clearly outlining the broker's responsibilities and the seller's obligations. This approach is correct because it prioritizes informed consent, transparency, and the broker's duty of care, all of which are fundamental to the Real Estate Services Act and ethical practice in New Brunswick. It ensures the seller is making decisions based on sound advice and a clear understanding of the process. An approach where the broker immediately lists the property at the seller's requested price without any market analysis or discussion of marketing strategy fails to uphold the duty of care and the obligation to provide competent service. This could lead to the property being significantly overpriced, resulting in a prolonged listing period, potential dissatisfaction for the seller, and a failure to achieve the best possible outcome. It also bypasses the crucial step of advising the seller on market realities, which is an ethical and regulatory expectation. Another incorrect approach involves the broker agreeing to market the property exclusively through social media channels without considering broader marketing strategies or the seller's overall financial goals. While social media can be a component of marketing, relying solely on it without professional judgment about its effectiveness for a particular property type and price point, and without discussing other options, may not fulfill the broker's obligation to market the property to the widest possible audience. This could be seen as a failure to exercise professional skill and diligence. Finally, an approach where the broker focuses solely on securing a quick sale without adequately discussing the implications of the sale price or the terms with the seller, potentially pressuring them into accepting an offer that is not in their best interest, is ethically unsound and violates the fiduciary duty owed to the client. The broker's role is to facilitate a transaction that benefits the seller, not just to close a deal quickly. Professionals should employ a decision-making framework that begins with a thorough understanding of the client's objectives, followed by an assessment of market conditions, and then the development of a tailored strategy that complies with all relevant legislation and ethical codes. This involves open communication, providing expert advice, and ensuring the client is fully informed at every stage of the transaction. Question 2. The control framework reveals that a client in New Brunswick is eager to finalize their mortgage application and has expressed a desire to sign all necessary documents immediately to secure the best interest rate, which is set to expire within 48 hours. The mortgage commitment letter and associated disclosure documents have just been received. What is the most responsible course of action for the real estate broker to ensure compliance with New Brunswick's regulatory framework and ethical obligations? Option A. Provide the client with all disclosure documents immediately. Schedule a dedicated meeting to thoroughly explain each section, answer all questions, and encourage them to take their time to review before signing, even if it means potentially missing the rate deadline. Option B. Present all documents at the signing appointment, verbally summarize the key terms, and advise the client that due to the impending deadline, a detailed review might not be feasible. Option C. Send the client a brief email outlining the main points of the mortgage commitment and instruct them to sign and return the documents electronically as soon as possible. Option D. Advise the client that the lender's deadline is paramount and that they should sign the documents without delay to secure the rate, as the broker has already verified the essential terms. The correct answer is A. Provide the client with all disclosure documents immediately. Schedule a dedicated meeting to thoroughly explain each section, answer all questions, and encourage them to take their time to review before signing, even if it means potentially missing the rate deadline. Explanation. The control framework reveals a common challenge in the mortgage application process, balancing the client's immediate needs with the regulatory requirements for disclosure and due diligence. This scenario is professionally challenging because the client is eager to proceed, potentially overlooking crucial information, while the broker has a legal and ethical obligation to ensure the client fully understands the mortgage terms and their implications. Failure to do so can lead to significant financial harm for the client and regulatory repercussions for the broker. The best professional approach involves proactively providing the client with all necessary disclosure documents, including the mortgage commitment and any associated riders or addenda, well in advance of the signing deadline. This allows the client ample time to review the information, ask questions, and seek independent advice if desired. The broker should then schedule a dedicated meeting to walk through the documents, explaining key clauses, interest rates, repayment schedules, fees, and any conditions or covenants. This ensures the client has a clear understanding of their obligations and the lender's expectations, aligning with the principles of informed consent and client best interests mandated by New Brunswick's real estate and mortgage brokering regulations. An incorrect approach would be to present the documents for the first time at the signing appointment without prior review or explanation. This fails to provide the client with adequate time for comprehension and decision-making, potentially leading to a misunderstanding of the mortgage terms. It also contravenes the spirit of transparency and client protection inherent in New Brunswick's regulatory framework, which emphasizes informed consent. Another incorrect approach is to only verbally summarize the key terms without providing the written documentation for review. While verbal explanations are important, they are not a substitute for comprehensive written disclosures. Regulations require that clients receive and understand the full terms of the mortgage agreement, and relying solely on verbal summaries leaves room for misinterpretation and omits critical details that may only be apparent in the written contract. Finally, an incorrect approach would be to pressure the client to sign the documents quickly due to the lender's deadline, implying that a thorough review is not necessary. This prioritizes closing the deal over the client's understanding and well-being, which is a direct violation of the broker's fiduciary duty and regulatory obligations to act in the client's best interest. Professionals should adopt a decision-making process that prioritizes client education and informed consent. This involves anticipating potential client anxieties or eagerness to proceed and proactively structuring the process to accommodate thorough review and understanding. Key steps include early disclosure, dedicated review sessions, clear and accessible explanations of complex terms, and encouraging clients to seek independent advice when appropriate, all within the bounds of New Brunswick's regulatory requirements. Question 3. Cost-benefit analysis shows that for a unique multi-unit residential building in Moncton, New Brunswick, with limited direct comparable sales and a strong rental market, which property valuation method would best reflect its market value and why? Option A. The cost approach focusing on the expense of rebuilding the property less depreciation. Option B, the comparative market analysis, relying on adjustments from the few available similar properties to estimate value. Option C, a hybrid approach combining elements of all three methods without prioritizing the primary value driver. Option D, the income approach, as it directly measures the property's ability to generate revenue, a key factor for investors in this market. The correct answer is D, the income approach, as it directly measures the property's ability to generate revenue, a key factor for investors in this market. Explanation: scenario analysis. This scenario presents a common challenge for real estate professionals in New Brunswick, determining the most appropriate valuation method for a unique commercial property with limited direct comparables. The challenge lies in balancing the need for a defensible valuation with the practical limitations of data availability. A broker must exercise professional judgment to select the method that best reflects the property's value, considering its specific characteristics and market conditions, while adhering to the Real Estate Agents Act of New Brunswick and its associated regulations. Failure to do so can lead to misrepresentation, client dissatisfaction, and potential disciplinary action. Correct approach analysis. The most appropriate approach in this scenario is the income approach. This method is best suited for income-generating properties, such as a multi-unit residential building, as it directly assesses the property's potential to produce revenue. It involves analyzing the net operating income, NOI, and applying a capitalization rate, cap rate, derived from comparable income-producing properties. In New Brunswick, real estate professionals are obligated under the Real Estate Agents Act to provide accurate and well-supported valuations. The income approach, when applied correctly with market-derived cap rates and realistic income projections, offers a robust and defensible valuation that aligns with the principles of fair market value for investment properties. This approach directly addresses the economic utility of the property, which is a primary driver of value for investors. Incorrect approaches analysis. Using the comparative market analysis, CMA, approach would be problematic. While CMAs are standard for residential properties, they rely heavily on direct comparisons with recently sold similar properties. For unique commercial property with few direct comparables, a CMA would likely result in a less reliable valuation. The lack of sufficient comparable sales data would make it difficult to make accurate adjustments, potentially leading to an inaccurate representation of value, which contravenes the duty of care owed to clients under New Brunswick real estate regulations. The cost approach, which estimates the cost to replace or reproduce the property, less depreciation, is also less suitable here. This method is generally most effective for newer, special-purpose properties where depreciation is easier to estimate and where income generation is not the primary value driver. For an older, income-producing commercial property, the cost approach may not accurately reflect the market value, as it doesn't directly consider the property's earning potential, a critical factor for investors in New Brunswick's commercial real estate market. Overlooking the income-generating capacity would be a failure to provide a comprehensive valuation. Professional reasoning. When faced with a unique property, a New Brunswick real estate professional should first identify the property's primary use and value driver. For income-producing properties, the income approach is typically the most relevant. If sufficient comparable sales exist, a CMA can be used as a secondary or supporting method. The cost approach is usually reserved for specific property types or as a check on other methods. The professional must document the chosen method, the data used, and the rationale for its selection, ensuring transparency and compliance with regulatory standards for valuation. Question 4. Analysis of a real estate brokerage's operational procedures in New Brunswick reveals a potential gap in ensuring salespersons maintain current licensing and complete mandatory continuing education. What is the most effective and compliant strategy for a broker to manage these requirements for their sales team? Option A. Rely exclusively on notifications from the New Brunswick Real Estate Association, NBREA, for renewal reminders and assume salespersons will act on them without brokerage oversight. Option B. Delegate the sole responsibility for tracking license renewals and continuing education to individual salespersons, assuming they will manage their own compliance. Option C. Implement a proactive internal system that tracks license expiry dates and continuing education deadlines, provides timely reminders to salespersons, and verifies completion of required credits. Option D. Address license, renewal, and continuing education only when a salesperson's license is nearing expiration, to avoid unnecessary administrative burden. Correct answer is C. Implement a proactive internal system that tracks license expiry dates and continuing education deadlines, provides timely reminders to salespersons, and verifies completion of required credits. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate broker in New Brunswick regarding the licensing and continuing education requirements for their salesperson. The core difficulty lies in ensuring compliance with the Real Estate Agents Act, New Brunswick, and its associated regulations, specifically concerning the timely renewal of licenses and the completion of mandatory continuing education. A broker has a supervisory responsibility to ensure their agents are properly licensed and up to date, and failure to do so can have significant legal and ethical repercussions for both the individual salesperson and the brokerage itself. This requires proactive management and clear communication. Correct approach analysis. The best professional approach involves the broker proactively establishing and enforcing a clear internal policy for license, renewal, and continuing education tracking. This policy should include regular reminders to salespersons well in advance of their license expiry dates and deadlines for completing continuing education credits. The broker should maintain a system for verifying the completion of these requirements, perhaps by requesting proof of attendance or certificates. This proactive and systematic approach directly aligns with the broker's duty of supervision under the Real Estate Agents Act, New Brunswick, and the New Brunswick Real Estate Association, NBREA, Code of Ethics, which emphasize ensuring that all individuals operating under the brokerage umbrella are properly licensed and adhere to professional standards. By implementing such a system, the broker mitigates the risk of non-compliance and upholds the integrity of the profession. Incorrect approach is analysis. Relying solely on individual salespersons to remember and manage their own license renewals and continuing education is a significant regulatory and ethical failure. The Real Estate Agents Act, New Brunswick, places a burden of supervision on the broker, making them accountable for the licensing status of their agents. This approach risks noncompliance due to oversight or forgetfulness by the salesperson, leading to potential fines, license suspension, or even revocation for the salesperson, and disciplinary action against the broker. Assuming that salespersons will automatically be notified by the NBREA about their renewal deadlines and continuing education requirements, and therefore no internal tracking is necessary, is also a flawed strategy. While the NBREA provides information, the ultimate responsibility for ensuring compliance rests with the broker. This passive stance can lead to missed deadlines and noncompliance, as individual notifications might be missed or overlooked by the salesperson. Waiting until a salesperson's license is close to expiring to inquire about their continuing education status is reactive and inefficient. This approach does not allow for adequate time to address any deficiencies or for the salesperson to complete the required credits if they have fallen behind. It creates a last-minute scramble that increases the likelihood of errors and noncompliance, undermining the broker's supervisory role. Professional reasoning. Professionals in New Brunswick's real estate industry must adopt a proactive and systematic approach to managing licensing and continuing education. This involves understanding the specific requirements of the Real Estate Agents Act, New Brunswick, and the NBREA guidelines. A robust internal system for tracking deadlines, providing reminders, and verifying compliance is essential. Brokers should foster a culture of accountability within their brokerage, where continuing education and license renewal are treated as critical professional obligations, not optional tasks. Regular communication and clear expectations are key to preventing noncompliance and ensuring ethical practice. Question 5. The review process indicates that a licensed real estate broker in New Brunswick has a close personal relationship with the seller of a property they are listing. A potential buyer, who is not aware of this relationship, expresses strong interest in the property and is considering making an offer. What is the most appropriate course of action for the broker to ensure compliance with New Brunswick's Real Estate Agents Act and ethical standards? Option A. Advise the prospective buyer to seek independent legal counsel to review the offer and the transaction details, without initially disclosing the broker's personal relationship with the seller. Option B. Proceed with facilitating the transaction, assuming the broker can remain impartial and only disclose the relationship if the buyer specifically asks about the broker's connection to the seller. Option C. Immediately disclose the personal relationship with the seller to the prospective buyer and obtain their informed consent to continue representing them in this transaction, while also ensuring the seller is fully aware of the broker's ongoing disclosure to the buyer. Option D. Inform the seller about the broker's personal relationship with the buyer and advise the seller to seek independent representation for this specific transaction. The correct answer is C. Immediately disclose the personal relationship with the seller to the prospective buyer and obtain their informed consent to continue representing them in this transaction, while also ensuring the seller is fully aware of the broker's ongoing disclosure to the buyer. Explanation. The review process indicates a common scenario in New Brunswick real estate where a broker must navigate potential conflicts of interest and ensure compliance with provincial real estate regulations. This situation is professionally challenging because it requires a proactive and transparent approach to maintain client trust and adhere to legal obligations. Failure to manage this effectively can lead to regulatory sanctions, reputational damage, and legal liabilities. The correct approach involves immediate and full disclosure of the material fact to all parties involved. This means informing both the seller and the prospective buyer about the broker's personal interest in the property. In New Brunswick, the Real Estate Agents Act and its associated regulations, particularly those concerning disclosure and conflicts of interest, mandate that registrants must act honestly and in good faith. This includes disclosing any personal interest in a transaction that could reasonably be expected to affect the client's interests. By disclosing the relationship, the broker allows both the seller and the buyer to make informed decisions and to decide whether they wish to proceed with the transaction or seek independent representation. This aligns with the ethical duty to avoid undisclosed conflicts of interest and to prioritize client interests. An incorrect approach would be to proceed with the transaction without disclosing the personal relationship to the buyer. This violates the duty of full disclosure required by New Brunswick real estate law. The buyer is entitled to know of any circumstances that might influence the broker's advice or actions, and withholding this information constitutes a breach of trust and regulatory requirements. Another incorrect approach would be to only disclose the relationship to the seller. While the seller is aware of the broker's interest, the buyer is still not fully informed. The broker's duty of disclosure extends to all parties whose interests could be affected by the undisclosed conflict. Failing to inform the buyer means the buyer cannot make a fully informed decision, potentially leading to a situation where the broker's advice is perceived as biased, even if the broker attempts to remain impartial. Finally, an incorrect approach would be to suggest the buyer seek independent legal counsel without first disclosing the broker's personal interest. While recommending independent advice is often good practice, it does not absolve the broker of their primary duty to disclose their own conflict of interest. The buyer needs to know about the broker's relationship to understand why independent advice might be particularly important in this specific transaction. Professionals should adopt a decision-making framework that prioritizes transparency and adherence to regulatory obligations. When a potential conflict of interest arises, the first step should always be to identify the nature of the conflict. Subsequently, the professional must consult the relevant provincial legislation and professional conduct guidelines to understand their specific duties. The next step is to determine the extent of disclosure required and to whom it must be made. Finally, the professional must act in accordance with these duties, ensuring that all parties are fully informed and that their decisions are based on complete information, thereby upholding both legal and ethical standards. Question 6. Performance analysis shows that clients in New Brunswick often seek to purchase property with family members or partners. When advising a client on purchasing a property with another individual, what is the most accurate and ethically sound approach to explaining the different forms of ownership available, specifically concerning how the property is held and what happens upon the death of one of the owners? Option A. Clearly explain that joint tenancy includes the right of survivorship, meaning the surviving owner, S, automatically inherit the deceased owner's share, and contrast this with tenancy in common, where each owner's share passes according to their will or intestacy laws, while also defining fee simple and leasehold interests. Option B. Advise that joint tenancy is the most common and straightforward way for multiple people to own property together, and that the specifics of inheritance are usually handled through a will, similar to tenancy in common. Option C. Emphasize that all forms of co-ownership, including joint tenancy and tenancy in common, allow each owner to sell their individual portion of the property independently at any time. Option D. Focus on the immediate financial benefits of shared ownership and suggest that the legal distinctions between joint tenancy and tenancy in common are minor and typically only become relevant in complex legal disputes. The correct answer is A. Clearly explain that joint tenancy includes the right of survivorship, meaning the surviving owner, S, automatically inherit the deceased owner's share, and contrast this with tenancy in common, where each owner's share passes according to their will or intestacy laws, while also defining fee simple and leasehold interests. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate broker in New Brunswick to accurately advise clients on the implications of different ownership structures, particularly when dealing with multiple parties and potential future disputes. Misunderstanding or misrepresenting these structures can lead to significant legal and financial consequences for the clients and professional liability for the broker. Careful judgment is required to ensure clients fully comprehend their rights and obligations under each type of ownership. Correct approach analysis. The best professional practice involves clearly explaining the fundamental differences between fee simple, leasehold, joint tenancy, and tenancy in common, emphasizing how each impacts ownership rights, inheritance, and the ability to sell or transfer the property. Specifically for joint tenancy, the broker must highlight the right of survivorship, meaning that upon the death of one joint tenant, their interest automatically passes to the surviving joint tenant, S, bypassing their will. This is crucial for clients who may have different intentions for their estate planning. This aligns with the New Brunswick Real Estate Act and its associated regulations, which mandate that registrants provide competent service and accurate information to clients regarding property transactions. Ethical obligations under the Real Estate Act require brokers to act in the best interests of their clients and to avoid misrepresentation. Incorrect approaches analysis. Advising clients that joint tenancy is simply a convenient way for multiple owners to hold property without clearly explaining the right of survivorship is a significant ethical and regulatory failure. This omission can lead to unintended consequences where a deceased owner's intended heirs do not inherit their share, directly contravening their estate planning wishes and potentially leading to disputes. This misrepresentation violates the duty of care and disclosure required by the New Brunswick Real Estate Act, suggesting that tenancy in common is identical to joint tenancy, particularly by downplaying or ignoring the absence of the right of survivorship in tenancy in common, is also a critical error. This can lead clients to believe their share will automatically pass to co-owners, when, in fact, it will pass according to their will or the laws of intestacy. This misstatement constitutes a failure to provide accurate information and can result in significant legal complications and client dissatisfaction, breaching professional conduct standards. Focusing solely on the immediate benefits of shared ownership without detailing the legal ramifications of each ownership type, such as the inability of a joint tenant to unilaterally sell their interest without the consent of all other joint tenants, is also professionally deficient. While shared ownership might be the immediate goal, failing to explain the restrictions and rights associated with each form of ownership, as mandated by property law in New Brunswick, leaves clients vulnerable to future conflicts and misunderstandings. This lack of comprehensive disclosure is a breach of the broker's duty to inform and protect the client's interests. Professional reasoning. Professionals should approach such situations by first identifying the client's objectives and then meticulously explaining the legal and practical implications of each ownership structure relevant to New Brunswick property law. This involves a comparative analysis, clearly delineating the rights, responsibilities, and potential future outcomes associated with fee simple, leasehold, joint tenancy, and tenancy in common. The decision-making process should prioritize client education and informed consent, ensuring that clients understand the long-term consequences of their choices before committing to a particular form of ownership. This proactive approach mitigates risk and upholds professional integrity. Question 7. Compliance review shows that a real estate contract in New Brunswick contains a clause that is causing significant confusion for your seller client regarding their obligations. The client believes their interpretation is correct, but you have reservations about its legal accuracy. What is the most appropriate course of action? Option A. Offer to renegotiate the clause with the buyer immediately to remove the ambiguity, without first seeking legal advice for your client. Option B. Advise the client to consult with a qualified legal professional to obtain an interpretation of the clause and understand their contractual rights and obligations. Option C. Proceed with the transaction based on your understanding of the clause, assuring the client that your interpretation is likely correct. Option D. Recommend that the client disregard the confusing clause and proceed with the sale as if it were not included in the contract. The correct answer is B. Advise the client to consult with a qualified legal professional to obtain an interpretation of the clause and understand their contractual rights and obligations. Explanation. Scenario analysis. This scenario presents a professional challenge because it involves a potential breach of contract due to a misunderstanding of a key term, which could lead to legal disputes and financial repercussions for all parties involved. Navigating such situations requires a thorough understanding of contract law in New Brunswick and adherence to ethical obligations as a real estate professional. The challenge lies in identifying the correct contractual interpretation and advising the client appropriately without overstepping professional boundaries or providing legal advice. Correct approach analysis. The best professional practice involves advising the client to seek independent legal counsel to interpret the ambiguous clause and understand their contractual obligations and rights. This approach is correct because real estate professionals in New Brunswick are regulated by the Real Estate Agents Act and its associated regulations, which mandate acting with honesty, integrity, and competence. While professionals must understand contracts, they are not lawyers and should not provide legal interpretations. Directing the client to a legal professional ensures they receive accurate legal advice, thereby protecting the client, the brokerage, and the professional from potential liability arising from misinterpretation. This aligns with the ethical duty to act in the client's best interest and to avoid practicing law without a license. Incorrect approach is analysis. Advising the client to proceed based on the professional's personal interpretation of the clause is professionally unacceptable. This constitutes providing legal interpretation without being qualified, which is a violation of the Real Estate Agents Act and potentially the unauthorized practice of law. It exposes the client to significant risk if the interpretation is incorrect and could lead to a breach of contract claim. Suggesting the client ignore the clause and proceed with the sale as if it were not present is also professionally unacceptable. This demonstrates a lack of diligence and a failure to uphold the contractual obligations of the agreement. It disregards the potential legal implications of an unaddressed contractual term and fails to protect the client's interests, violating the duty of care and competence owed to them. Attempting to renegotiate the clause without understanding its legal implications or advising the client on their legal standing is also professionally unsound. While negotiation is part of real estate transactions, doing so without a clear understanding of the legal ramifications of the existing clause could lead to an agreement that is not in the client's best interest or is legally unenforceable. This approach bypasses the crucial step of understanding the existing contractual rights and obligations. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes client protection and adherence to regulatory requirements. When faced with contractual ambiguity, the first step is to recognize the limitation of one's professional scope. The next step is to clearly communicate the need for specialized legal interpretation to the client. The professional should then facilitate the client's access to legal counsel without offering personal legal opinions or advice. This ensures that all parties are acting on sound legal footing, thereby mitigating risk and upholding professional integrity. Question 8. Investigation of a property management scenario in New Brunswick reveals that a tenant occupied a residential unit under a one-year fixed-term lease that has now expired. The tenant has remained in possession of the property with the landlord's knowledge and consent, and no new lease agreement has been signed. What is the most accurate legal classification of the tenant's occupancy and the applicable terms of their tenancy moving forward, according to New Brunswick's Residential Tenancies Act? Option A. The tenant is now considered a month-to-month tenant, but the original fixed-term lease conditions, including the specific expiry date, remain in effect. Option B. The tenant is now occupying the unit without a lease, allowing the landlord to unilaterally impose new terms and conditions for continued occupancy without tenant agreement. Option C. The tenant is now a trespasser, and the landlord can immediately demand possession of the property without further notice. Option D. The tenancy has automatically converted to a month-to-month periodic tenancy, where the terms of the original lease, excluding the fixed end date, continue to apply, and termination requires notice as per month-to-month tenancy rules. Correct answer is D. The tenancy has automatically converted to a month-to-month periodic tenancy, where the terms of the original lease, excluding the fixed end date, continue to apply, and termination requires notice as per month-to-month tenancy rules. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in New Brunswick to navigate the nuances of lease agreements, specifically distinguishing between a fixed-term lease and a periodic tenancy, and understanding the implications of a tenant's continued occupancy after the lease expiry without a new agreement. Misinterpreting the lease type or the tenant's rights can lead to legal disputes, financial losses for the landlord or tenant, and damage to the broker's professional reputation. Adherence to the Residential Tenancies Act of New Brunswick is paramount. Correct approach analysis. The best professional approach involves recognizing that when a fixed-term lease expires and the tenant remains in possession of the property with the landlord's consent, and no new lease agreement is signed, the tenancy automatically converts to a month-to-month periodic tenancy under the Residential Tenancies Act of New Brunswick. This means the original terms of the expired lease, except for the fixed end date, continue to apply, and either party can terminate the tenancy by providing the notice period required for a month-to-month tenancy as stipulated by the Act. This approach correctly applies the statutory provisions governing lease conversions in New Brunswick. Incorrect approaches analysis. One incorrect approach is to assume the tenant is now a month-to-month tenant, but that the original fixed-term lease conditions, including the specific expiry date, somehow remain in effect. This is incorrect because the Residential Tenancies Act explicitly states that upon expiry of a fixed term and continued occupancy with consent, the tenancy becomes periodic, and the fixed end date is superseded by the periodic nature of the tenancy. Another incorrect approach is to consider the tenant a trespasser or to attempt to force the tenant out immediately without proper notice, based on the expired fixed term. This is a significant regulatory failure, as it disregards the tenant's rights under the Residential Tenancies Act, which protects tenants from arbitrary eviction and mandates specific notice periods for termination, even after a fixed term has ended and the tenancy has converted to periodic. A further incorrect approach is to assume that because no new lease was signed, the landlord can unilaterally impose new terms and conditions on the tenant without mutual agreement, effectively treating it as a new tenancy negotiation from scratch. While a landlord can propose new terms for a new lease, the existing month-to-month tenancy operates under the terms of the previous lease, minus the fixed end date, until new terms are agreed upon by both parties. This approach fails to acknowledge the statutory continuation of the tenancy under existing, albeit modified, terms. Professional reasoning. Professionals should employ a systematic approach. First, identify the original lease type, fixed term. Second, determine the tenant's status post-expiry, continued occupancy with consent. Third, consult the Residential Tenancies Act of New Brunswick to understand the statutory implications of this situation, specifically regarding lease conversion to periodic tenancy. Fourth, advise the landlord and tenant on their respective rights and obligations under the converted periodic tenancy, emphasizing the required notice periods for termination. This structured process ensures compliance with provincial legislation and ethical obligations. Question 9. Comparative studies suggest that a nuanced understanding of real estate financing is crucial for client satisfaction and successful transactions in New Brunswick. A real estate broker is assisting a client who is purchasing a property and is seeking guidance on mortgage options. The client has expressed a desire for the lowest possible monthly payment. Which of the following approaches best balances the broker's professional obligations with the client's need for information and guidance regarding financing? Option A. Recommend a specific mortgage product that typically offers the lowest initial interest rate based on the broker's experience, and assure the client that this will result in the lowest monthly payment. Option B. Advise the client to focus solely on securing the lowest possible interest rate, suggesting they explore options with the longest possible amortization period to minimize immediate monthly payments. Option C. Explain the general characteristics and potential impacts of various mortgage products available in New Brunswick, such as fixed-rate versus variable-rate mortgages, and the implications of different amortization periods on monthly payments and total interest paid. Then advise the client to consult with a qualified mortgage broker or financial advisor for personalized advice and pre-approval. Option D. Calculate for the client the maximum mortgage amount they can afford based on their stated income and debts, and then suggest they seek a mortgage product that fits within that calculated affordability range. The correct answer is C. Explain the general characteristics and potential impacts of various mortgage products available in New Brunswick, such as fixed-rate versus variable-rate mortgages, and the implications of different amortization periods on monthly payments and total interest paid. Then advise the client to consult with a qualified mortgage broker or financial advisor for personalized advice and pre-approval. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in New Brunswick to navigate the complexities of financing options for a client while adhering to their fiduciary duties and regulatory obligations. The broker must ensure the client fully understands the implications of different financing structures, particularly concerning the potential for future financial strain, without providing unlicensed financial advice. The challenge lies in balancing the client's immediate needs with their long-term financial well-being and maintaining professional boundaries. Correct approach analysis. The best professional practice involves the broker thoroughly explaining the general characteristics and potential impacts of various mortgage products available in New Brunswick, such as fixed-rate versus variable-rate mortgages, and the implications of different amortization periods on monthly payments and total interest paid. This approach educates the client on the fundamental differences and risks associated with each, empowering them to make an informed decision. Crucially, the broker must then advise the client to consult with a qualified mortgage broker or financial advisor for personalized advice and to secure pre-approval. This aligns with the Real Estate Agents Act of New Brunswick, which mandates that registrants act honestly and in good faith, and specifically prohibits the provision of financial advice that falls outside the scope of real estate services. By facilitating informed understanding and directing the client to appropriate professionals for specific financial guidance, the broker fulfills their duty of care and avoids unauthorized practice. Incorrect approaches analysis. Recommending a specific mortgage product based on the broker's personal experience or perceived client preference, without a comprehensive understanding of the client's full financial picture, and without advising consultation with a financial expert, constitutes a failure to act in the client's best interest. This could lead to the client selecting a product that is not suitable for their financial situation, potentially causing future hardship. Such an action could be construed as providing unlicensed financial advice, a violation of regulatory boundaries, suggesting that the client prioritize the lowest possible interest rate without discussing the associated risks, such as the potential for rate increases with variable mortgages or the long-term cost implications of extended amortization periods, is also professionally unsound. This overlooks the broader financial implications and the client's overall risk tolerance, failing to provide a balanced perspective. Directly advising the client on how much mortgage they can afford based on their income and debts, without the client having obtained formal pre-approval from a lender or consulted a mortgage professional, crosses the line into financial advising. This is a critical regulatory boundary that real estate brokers in New Brunswick must not breach, as they are not licensed to provide such specific financial assessments. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes client education and directs them to appropriate specialists for advice beyond the scope of real estate services. This involves clearly outlining the general features and potential consequences of different financing options, emphasizing the importance of independent financial consultation, and facilitating the client's access to qualified mortgage brokers or financial advisors. This approach ensures compliance with regulatory requirements, upholds fiduciary duties, and protects both the client and the broker from potential liabilities. Question 10. The investigation demonstrates that a client in New Brunswick is seeking to purchase a property with a mortgage requiring private mortgage insurance, PMI. The mortgage amount is $300,000. The interest rate is 5% per annum, and the amortization period is 25 years. The PMI premium is calculated as 2.75% of the mortgage principal, payable upfront. The broker needs to advise the client on the total monthly mortgage payment, including the amortized PMI premium. What is the correct total monthly mortgage payment, rounded to the nearest dollar, assuming the PMI premium is amortized over the same 25-year period? Option A. The total monthly mortgage payment, including the amortized PMI, is $1,750. Option B. The total monthly mortgage payment, including the amortized PMI, is $1,590. Option C. The total monthly mortgage payment, including the amortized PMI, is $1,680. Option D. The total monthly mortgage payment, including the amortized PMI, is $1,809. The correct answer is D. The total monthly mortgage payment, including the amortized PMI, is $1,809. Explanation. This scenario presents a common challenge in New Brunswick real estate brokerage, where a broker must accurately assess the financial implications of private mortgage insurance, PMI, for a client. The challenge lies in understanding how PMI premiums are calculated and how they impact the overall cost of borrowing, ensuring transparency and informed decision-making for the client. A broker's duty extends beyond facilitating a transaction to providing sound financial guidance within their scope of expertise. The best professional practice involves calculating the total cost of the mortgage, including the PMI premium, and presenting this comprehensive figure to the client. This approach ensures the client has a clear understanding of the true cost of their mortgage financing. In New Brunswick, while specific regulations on PMI calculation methods are not detailed in the prompt, the overarching principle of full disclosure and acting in the client's best interest, as guided by the Real Estate Agents Act of New Brunswick and its associated regulations, mandates that all associated costs be clearly communicated. This includes the amortization of the PMI premium over the life of the mortgage, which provides a more realistic monthly payment figure for the client. An incorrect approach would be to simply state the gross mortgage amount without factoring in the PMI premium. This fails to meet the ethical obligation of full disclosure and can mislead the client about their actual financial obligations. Another incorrect approach is to only calculate the PMI as a single upfront payment without considering its amortization. While the premium is paid upfront, its financial impact is spread over the mortgage term, and presenting it solely as a lump sum can distort the client's perception of their ongoing monthly expenses. Finally, an approach that estimates the PMI premium without a clear calculation method is unprofessional and lacks the precision required for financial advice, potentially leading to significant discrepancies and client dissatisfaction. Professionals should approach such situations by first identifying all components of the mortgage cost, including interest, principal, and any associated insurance premiums. They should then utilize the relevant formulas to accurately calculate these costs over the mortgage term. Transparency and clear communication with the client are paramount, ensuring they understand all financial implications before committing to the mortgage. Question 11. Assessment of a real estate broker's responsibilities in New Brunswick when a client inquires about the suitability of fixed-rate, adjustable rate, and interest-only mortgages for their upcoming property purchase. What is the most appropriate professional approach? Option A. Provide a detailed analysis of potential future interest rate scenarios and their impact on each mortgage type, guiding the client towards the option that appears most financially advantageous based on these projections. Option B. Offer to assist the client in applying for a mortgage, explaining the features of each product as part of the application process and helping them select the one that aligns with their perceived financial capacity. Option C. Recommend an adjustable rate mortgage, suggesting it is likely the most beneficial option given current market trends and the client's stated desire for lower initial payments. Option D. Explain the general characteristics of each mortgage type, including how interest rate fluctuations affect payments for adjustable rate mortgages, and advise the client to consult with a mortgage specialist or financial advisor to determine the best product for their individual financial circumstances. The correct answer is D. Explain the general characteristics of each mortgage type, including how interest rate fluctuations affect payments for adjustable rate mortgages, and advise the client to consult with a mortgage specialist or financial advisor to determine the best product for their individual financial circumstances. Explanation. Scenario analysis. This scenario presents a professional challenge because a real estate broker must advise a client on mortgage options without engaging in financial advice that falls outside their licensing scope. The broker's duty is to facilitate the transaction and provide information relevant to real estate, not to act as a mortgage broker or financial planner. Misrepresenting the nature of mortgage products or steering a client towards a product based on incomplete or inappropriate advice can lead to significant financial harm for the client and regulatory repercussions for the broker. Careful judgment is required to balance providing helpful information with respecting professional boundaries and regulatory limitations. Correct approach analysis. The best professional practice involves clearly explaining the fundamental differences between fixed-rate, adjustable-rate, and interest-only mortgages in terms of their payment structures and how interest rates affect them, while explicitly stating that the choice of mortgage product is a financial decision for the client to make in consultation with a qualified financial advisor or mortgage specialist. This approach is correct because it aligns with the new Brunswick Real Estate Act and its associated regulations, which permit brokers to provide general information about real estate transactions, but prohibit them from offering financial advice or acting as mortgage brokers without the appropriate licensing. By focusing on the informational aspects of the mortgage types and deferring the decision-making to the client and their financial professionals, the broker upholds their fiduciary duty to the client by acting honestly and competently within their scope of practice, avoiding any appearance of providing unlicensed financial advice. Incorrect approaches analysis. Recommending a specific mortgage type based on the broker's perception of the client's financial situation, even if presented as a helpful suggestion, constitutes providing financial advice. This is an ethical and regulatory failure because it exceeds the broker's licensing authority in New Brunswick and could lead to a client choosing a mortgage product that is not suitable for their financial circumstances, potentially resulting in default or undue financial strain. Providing a detailed comparison of mortgage products that includes projections of future interest rate changes and their potential impact on monthly payments, framed as guidance for the client's decision, also crosses the line into financial advising. This is problematic as it involves making assumptions about future market conditions and the client's risk tolerance, which are areas requiring specialized financial expertise and licensing. Focusing solely on the features of each mortgage type without any disclaimer about the need for professional financial consultation and implying that this information is sufficient for the client to make an informed decision is also an inadequate approach. While not explicitly giving advice, it can create a misleading impression that the broker's information is comprehensive financial guidance, thereby failing to adequately protect the client by not directing them to appropriate financial expertise for a critical financial decision. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes client welfare and strict adherence to regulatory boundaries. This involves understanding the scope of their license and expertise, clearly communicating what information they can and cannot provide, and proactively directing clients to other licensed professionals when a situation requires specialized knowledge or advice outside the broker's purview. In this case, the broker's role is to facilitate the real estate transaction by providing relevant property information and general market context, not to guide financial product selection. Question 12. Process analysis reveals that a real estate broker in New Brunswick is assisting a client who is interested in purchasing a property and has inquired about the possibility of using government-backed loans such as FHA, VA, or USDA loans to finance their purchase. Considering the broker's role and responsibilities under New Brunswick real estate regulations, which of the following approaches best represents professional conduct and client advocacy? Option A. Advise the client that they are definitively eligible for a USDA loan based on their stated income and credit score, as this program typically offers favorable terms for rural property purchases. Option B. Thoroughly educate the client on the general characteristics and potential benefits of FHA, VA, and USDA loans, clearly explaining that these are federal programs with specific eligibility requirements that necessitate formal verification by lenders and federal agencies, and guide the client to appropriate professionals for detailed assessment. Option C. Focus exclusively on the lower down payment requirements of FHA loans, without mentioning any potential property condition requirements or appraisal standards that might apply. Option D. Downplay the eligibility hurdles for FHA and VA loans, assuring the client that these programs are readily accessible for most first-time homebuyers in New Brunswick. Correct answer is B. Thoroughly educate the client on the general characteristics and potential benefits of FHA, VA, and USDA loans, clearly explaining that these are federal programs with specific eligibility requirements that necessitate formal verification by lenders and federal agencies, and guide the client to appropriate professionals for detailed assessment. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate broker in New Brunswick to navigate the complexities of government-backed loan programs, specifically the FHA, VA, and USDA loans, while ensuring compliance with provincial regulations and ethical obligations. Misunderstanding or misrepresenting the eligibility criteria, benefits, or limitations of these programs can lead to significant financial repercussions for the buyer, legal liabilities for the broker, and damage to the broker's reputation. The broker must act in the best interest of their client, providing accurate and unbiased information. Correct approach analysis. The best professional practice involves thoroughly educating the client about the general characteristics and potential benefits of FHA, VA, and USDA loans, emphasizing that these are federal programs with specific eligibility requirements that may differ from provincial standards. The broker should clearly explain that while these programs can offer advantages like lower down payments or more flexible credit requirements, they are not universally applicable and require a formal application and approval process with the respective federal agencies. The broker's role is to facilitate access to information and guide the client through the process of determining eligibility with the appropriate lenders and federal agencies, rather than making definitive pronouncements on eligibility or guaranteeing approval. This approach aligns with the ethical duty of competence and diligence, ensuring the client is well informed and empowered to make decisions based on accurate information, and adheres to the principles of acting in the client's best interest by not overpromising or misrepresenting program details. Incorrect approaches analysis. One incorrect approach is to directly advise the client that they are definitively eligible for a specific government-backed loan program based solely on their initial conversation and without verifying with the lender or federal agency. This is professionally unacceptable because it constitutes providing financial advice beyond the broker's scope and expertise, and it risks misrepresenting eligibility, which can lead to the client incurring costs or making decisions based on false premises. Provincial real estate regulations mandate that brokers act within their licensed capacity and avoid offering services for which they are not qualified. Another incorrect approach is to downplay the complexities and eligibility requirements of FHA, VA, or USDA loans, suggesting they are simple alternatives to conventional financing without detailing the necessary steps for qualification. This failure to provide comprehensive and accurate information violates the duty of disclosure and can mislead the client into believing they have guaranteed access to these programs, potentially causing disappointment and financial strain if they are later found to be ineligible. A further incorrect approach is to focus solely on the potential benefits of these government-backed loans without adequately explaining the potential drawbacks or limitations, such as property condition requirements or appraisal standards specific to FHA, VA, or USDA loans. This selective disclosure is ethically problematic as it does not present a balanced view, preventing the client from making a fully informed decision. Professional reasoning. Professionals should adopt a client-centric approach, prioritizing education and accurate information dissemination. When dealing with specialized financial products like government-backed loans, the decision-making process should involve 1. Identifying the client's needs and financial situation. 2. Researching available financing options, including government-backed programs, and understanding their general parameters. 3. Clearly communicating the nature of these programs, their potential benefits, and their specific eligibility criteria, while emphasizing the need for formal lender and federal agency verification. 4. Guiding the client to qualified mortgage brokers or lenders who specialize in these loan types for definitive eligibility assessment. 5. Maintaining transparency and avoiding any statements that could be construed as guarantees of loan approval or eligibility. Question 13. Regulatory review indicates that a real estate investor in New Brunswick seeking advice on whether to purchase a commercial property in a rapidly developing urban area given recent strong appreciation in property values. What is the most prudent approach for a New Brunswick licensed real estate broker to take when advising this client? Option A. Recommend that the client postpone the purchase indefinitely, suggesting that the current market is too volatile and that they should wait for a more stable, predictable market to emerge. Option B. Base the advice solely on the broker's personal experience and intuition regarding the future direction of the New Brunswick real estate market, without consulting specific market data or economic forecasts. Option C. Advise the client that the current strong appreciation indicates a guaranteed continuation of positive returns, encouraging immediate purchase to capitalize on the ongoing market boom. Option D. Conduct a thorough analysis of current and historical market data for the specific New Brunswick region, considering economic indicators, interest rate trends, and local development plans, to present a balanced view of potential opportunities and risks associated with the investment, emphasizing the cyclical nature of real estate markets. Correct answer is D. Conduct a thorough analysis of current and historical market data for the specific New Brunswick region, considering economic indicators, interest rate trends, and local development plans, to present a balanced view of potential opportunities and risks associated with the investment, emphasizing the cyclical nature of real estate markets. Explanation. This scenario presents a professional challenge because real estate market cycles and trends significantly impact property values and investment viability. A real estate professional in New Brunswick must navigate these fluctuations responsibly, providing clients with accurate and timely advice that aligns with their investment goals and risk tolerance, while adhering to the Real Estate Agents Act of New Brunswick and its associated regulations. The challenge lies in interpreting market data, forecasting potential future trends, and communicating this complex information effectively and ethically to clients. The best professional approach involves a comprehensive analysis of current and historical market data specific to New Brunswick, considering factors like interest rates, economic growth, population shifts, and local development projects. This analysis should then be used to provide clients with a balanced perspective on potential risks and opportunities associated with their investment decisions, emphasizing that past performance is not indicative of future results. This aligns with the ethical obligations under the Real Estate Agents Act of New Brunswick to act with honesty, integrity, and in the best interest of the client, ensuring they are fully informed to make sound decisions. An incorrect approach would be to solely focus on recent positive market performance and present an overly optimistic outlook without acknowledging potential downturns or the cyclical nature of the market. This fails to meet the duty of care to the client by omitting crucial information about risks and potential negative impacts of market shifts, potentially leading to poor investment choices and contravening the requirement to provide accurate and complete information. Another incorrect approach is to dismiss current market trends as irrelevant and advise clients to wait indefinitely for a perceived perfect market. This demonstrates a lack of understanding of market dynamics and a failure to assist clients in making timely decisions, potentially causing them to miss out on viable opportunities due to inaction. It also neglects the professional obligation to guide clients through the current market landscape. Finally, an incorrect approach would be to base advice solely on anecdotal evidence or personal opinions about market direction, without supporting it with objective data and analysis. This lacks the professional rigor required and can lead to misinformed decisions, violating the trust placed in the real estate professional and the standards expected under New Brunswick's real estate regulations. Professionals should employ a decision-making framework that prioritizes client education and informed consent. This involves continuous market research, objective data analysis, clear and transparent communication of both opportunities and risks, and tailoring advice to individual client circumstances and risk appetites, always within the bounds of regulatory compliance and ethical conduct. Question 14. Consider a scenario where a client in New Brunswick expresses interest in diversifying their investment portfolio and asks their real estate broker about the potential of investing in real estate investment trusts, REIT, as a way to gain exposure to the real estate market without the direct responsibilities of property ownership. What is the most appropriate course of action for the New Brunswick real estate broker? Option A. Explain REIT as a simple extension of direct real estate investment, focusing on the underlying property assets and downplaying any differences in regulatory oversight. Option B. Recommend specific rate that the broker believes are performing well based on general market knowledge and their understanding of real estate trends. Option C. Offer to assist the client in purchasing rate units as part of the overall real estate transaction, assuming the broker can facilitate the necessary paperwork. Option D. Advise the client that rate are typically considered securities and that the broker's license does not permit them to provide investment advice on such products, recommending they consult with a licensed securities advisor for personalized guidance. The correct answer is D. Advise the client that rate are typically considered securities and that the broker's license does not permit them to provide investment advice on such products, recommending they consult with a licensed securities advisor for personalized guidance. Explanation. Scenario analysis. This scenario presents a professional challenge for a New Brunswick real estate broker because it involves advising a client on a complex investment vehicle that has specific regulatory considerations under New Brunswick law. The broker must navigate the distinction between providing general real estate advice and offering investment advice, which may fall under different regulatory regimes. Misinterpreting the scope of their license or failing to understand the implications of rate for their client could lead to significant legal and ethical breaches, including potential liability for misrepresentation or unauthorized practice of securities law. Careful judgment is required to ensure the client's best interests are protected while adhering strictly to the broker's licensing obligations in New Brunswick. Correct approach analysis. The best professional practice involves clearly delineating the broker's role and responsibilities. This means acknowledging the client's interest in rate, explaining that rate are typically considered securities and are therefore outside the direct purview of a real estate broker's license in New Brunswick. The broker should then advise the client to seek independent, qualified financial and investment advice from a licensed securities advisor or financial planner, who can properly assess the risks and suitability of rate investments for the client's specific financial situation. This approach upholds the broker's duty of care by not overstepping their licensing boundaries and ensuring the client receives appropriate, specialized advice. It aligns with the principles of professional conduct expected of New Brunswick real estate licensees, which emphasize acting with integrity and competence within the scope of their authority. Incorrect approaches analysis. Recommending specific rate without proper licensing or qualification is a significant regulatory failure. A New Brunswick real estate broker's license does not authorize them to provide advice on securities investments. Doing so constitutes the unauthorized practice of securities law, which is a serious offense and exposes the broker to legal penalties and disciplinary action from the relevant regulatory bodies. Suggesting that rate are simply another form of real estate ownership, akin to direct property investment, is also an ethical and regulatory misstep. While rate invest in real estate, their structure as publicly traded or privately held investment funds means they are regulated as securities. Failing to recognize this distinction can lead to a client making investment decisions based on incomplete or inaccurate information, potentially resulting in financial harm. Offering to facilitate the purchase of rate units as part of a broader real estate transaction, without disclosing the need for separate securities advice, is misleading. This implies the broker has the authority and expertise to handle such transactions, which they do not. This misrepresentation violates the duty of honesty and transparency owed to the client, and contravenes the regulatory framework governing real estate professionals in New Brunswick. Professional reasoning. Professionals in New Brunswick should adopt a decision-making framework that prioritizes client welfare and strict adherence to regulatory boundaries. When faced with a client inquiry that touches upon areas outside their licensing scope, the first step is to identify the nature of the inquiry. If it pertains to investments like rate, which are securities, the professional must immediately recognize that their expertise and license are insufficient. The subsequent action should be to clearly communicate these limitations to the client and strongly recommend seeking advice from a qualified professional in the relevant field, such as a licensed securities advisor. This ensures the client receives accurate and appropriate guidance, while the professional maintains their ethical standing and regulatory compliance. Question 15. Upon reviewing a potential investment property in Moncton, New Brunswick, an investor client expresses interest in utilizing financing options beyond traditional bank mortgages. They are considering a hard money loan due to its speed of approval and a seller financing arrangement to potentially negotiate more flexible terms. As their licensed real estate broker, what is the most prudent course of action to ensure you are acting in your client's best interest and complying with New Brunswick's real estate regulations? Option A. Recommend the hard money loan immediately, emphasizing its quick approval process, as this will allow for a faster closing and potentially a higher commission for you, without extensive discussion of the associated risks. Option B. Facilitate the seller financing arrangement by drafting the necessary agreement yourself, as this will expedite the process and demonstrate your expertise, without requiring the client to consult with a lawyer. Option C. Conduct a thorough assessment of the investor-client's financial capacity, risk tolerance, and investment goals, and provide a detailed explanation of the significant risks, costs, and repayment obligations associated with both hard money loans and seller financing, strongly advising the client to seek independent legal and financial advice before proceeding with either option. Option D. Advise the client that only traditional bank mortgages are permissible for real estate investments in New Brunswick, and steer them away from exploring hard money loans or seller financing. The correct answer is C. Conduct a thorough assessment of the investor-client's financial capacity, risk tolerance, and investment goals, and provide a detailed explanation of the significant risks, costs, and repayment obligations associated with both hard money loans and seller financing, strongly advising the client to seek independent legal and financial advice before proceeding with either option. Explanation. This scenario presents a professional challenge because it requires a real estate broker in New Brunswick to navigate the complexities of financing options beyond traditional mortgages, specifically hard money loans and seller financing, while ensuring compliance with provincial regulations and ethical obligations to their client. The broker must assess the suitability and risks of these non-traditional financing methods for their investor client, considering the client's financial capacity, risk tolerance, and the specific terms of the proposed transactions. A critical aspect is understanding the disclosure requirements and potential conflicts of interest inherent in these arrangements. The best approach involves a thorough due diligence process that prioritizes the client's best interests and adheres to the Real Estate Agents Act, New Brunswick, and its associated regulations. This includes a comprehensive assessment of the investor-client's financial situation, investment goals, and risk tolerance. For hard money loans, the broker must ensure the client understands the high interest rates, short repayment terms, and the significant risk of foreclosure. For seller financing, the broker must facilitate clear and transparent negotiations, ensuring all terms are documented and understood by both parties, and that the client is aware of their obligations and the potential implications of default. This approach emphasizes informed consent and risk mitigation, aligning with the broker's fiduciary duty. An incorrect approach would be to simply present hard money loans as a quick solution, without adequately explaining the substantial risks and costs associated with them, such as the exceptionally high interest rates and short repayment periods that can lead to rapid equity loss and foreclosure if the investor cannot meet the repayment schedule. This fails to uphold the duty of care and diligence required by provincial regulations, as it does not ensure the client is fully informed of the potential negative consequences. Another incorrect approach is to facilitate a seller financing agreement without ensuring independent legal counsel for the investor client. While seller financing can be beneficial, it involves complex legal documentation and potential liabilities. Failing to advise the client to seek independent legal advice before signing a seller financing agreement could expose them to unforeseen risks and contractual pitfalls, violating the principle of acting in the client's best interest and potentially contravening regulatory guidance on professional conduct. Finally, an incorrect approach would be to recommend a hard money loan seller financing arrangement primarily because it would lead to a faster closing or a higher commission for the broker, without a thorough assessment of its suitability for the client. This prioritizes the broker's financial gain over the client's welfare, constituting a serious ethical breach and a violation of the fiduciary duty owed to the client under New Brunswick real estate law. Professionals should adopt a decision-making framework that begins with a deep understanding of the client's needs and objectives. This is followed by a comprehensive evaluation of all available financing options, including their associated risks, benefits, and costs. For non-traditional options like hard money loans and seller financing, This evaluation must be particularly rigorous, involving detailed disclosure to the client, and where appropriate, recommending independent professional advice, legal and financial. The broker's role is to facilitate an informed decision by the client, not to make the decision for them, always acting with integrity and in their client's best interest. Question 16. When evaluating a property listing in New Brunswick for a client, a real estate broker discovers a significant, previously undisclosed foundation issue that was not apparent from a visual inspection. The seller is aware of the issue but wishes to proceed with the sale without explicitly mentioning it to potential buyers, hoping it will not be discovered. What is the most appropriate course of action for the broker to ensure regulatory compliance and professional integrity? Option A. Recommend to the seller that they do not disclose the foundation issue and rely on the buyer's home inspection to reveal any problems. Option B. Withhold information about the foundation issue from all potential buyers until an offer is made, then disclose it to that specific buyer. Option C. Advise the seller that the foundation issue is a material latent defect that must be disclosed to all potential buyers as per New Brunswick real estate regulations. Option D. Proactively disclose the known material latent defect to all prospective buyers and their agents, ensuring they are fully informed about the property's condition. Correct answer is D. Proactively disclose the known material latent defect to all prospective buyers and their agents, ensuring they are fully informed about the property's condition. Explanation. This scenario is professionally challenging because it requires a broker to balance the fiduciary duty owed to their client with the legal obligation to disclose material facts, even when those facts might negatively impact a potential sale. The broker must navigate potential conflicts of interest and ensure transparency in accordance with New Brunswick's real estate regulations. Careful judgment is required to avoid misrepresentation or concealment, which could lead to legal repercussions and damage to the brokerage reputation. The best approach involves proactively disclosing the known material latent defect to all prospective buyers and their agents. This aligns with the broker's duty of honesty and integrity, as mandated by the Real Estate Agents Act of New Brunswick and its associated regulations. By informing all parties, the broker ensures that buyers can make informed decisions based on complete information. This transparency upholds the principle of fair dealing and prevents potential future disputes arising from undisclosed issues. An incorrect approach involves withholding information about the foundation issue from potential buyers. This failure to disclose a material latent defect is a direct violation of the broker's statutory obligations. It constitutes misrepresentation by omission and breaches the duty of honesty and fair dealing owed to all parties in a transaction. Such concealment can lead to legal liability for the broker and the brokerage, including potential rescission of the sale and damages. Another incorrect approach is to only disclose the foundation issue to the buyer who eventually makes an offer, after other potential buyers have been shown the property without this knowledge. This selective disclosure is unethical and potentially illegal. It creates an unfair advantage for one buyer over others, and still involves a period where material information was withheld from the broader market, violating the principle of transparency and fair dealing throughout the marketing process. A further incorrect approach is to advise the seller to simply hope for the best and not disclose the foundation issue, relying on the buyer to discover it during their own inspection. This abdicates the broker's professional responsibility to ensure full disclosure of known material facts. It prioritizes the seller's immediate desire to sell without regard for the legal and ethical obligations of the brokerage to all parties involved in the transaction. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves identifying all known material facts, understanding the legal and ethical obligations to disclose them, and communicating this information transparently and promptly to all relevant parties. When in doubt, seeking clarification from regulatory bodies or legal counsel is a prudent step to ensure adherence to all requirements. Question 17. The analysis reveals that a client in Fredericton, New Brunswick, is eager to sell their investment property quickly due to personal circumstances and has set an asking price based on a recent appraisal they received. As their real estate broker, what is the most professionally responsible approach to advising them on pricing and market strategy? Option A. Advise the client to accept the first offer received, regardless of its value. Guarantee a swift transaction and fulfill their immediate need for liquidity. Option B. Focus the CMA exclusively on the highest comparable sale in the area to support the client's desired price, ensuring a quick sale is facilitated. Option C. Accept the client's stated asking price without further investigation, as their appraisal provides sufficient justification and their desire for a quick sale should be prioritized. Option D. Conduct a comprehensive comparative market analysis, CMA, that includes recent sales of similar properties, current market conditions in Fredericton, and an assessment of the property's investment potential. Then present this data to the client to inform their pricing decision. The correct answer is D. Conduct a comprehensive comparative market analysis, CMA, that includes recent sales of similar properties, current market conditions in Fredericton, and an assessment of the property's investment potential. Then present this data to the client to inform their pricing decision. Explanation. This scenario is professionally challenging because it requires the real estate broker to balance the client's immediate desire for a quick sale with the fiduciary duty to ensure the client receives fair market value, as mandated by the Real Estate Agents Act, New Brunswick, and its associated regulations. The broker must act in the client's best interest, which includes providing sound advice on investment potential and market realities, not just facilitating a transaction. The best professional practice involves conducting a comprehensive comparative market analysis, CMA, that considers the property's current condition, recent sales of comparable properties in the Fredericton area, and potential future market trends. This approach is correct because it directly aligns with the broker's obligation under the Real Estate Agents Act to act with honesty, integrity, and in the best interests of the client. A thorough CMA provides the client with an informed basis for setting a realistic asking price and understanding the property's true investment potential, thereby fulfilling the duty of care and competence. An approach that focuses solely on the seller's stated price without independent verification is professionally unacceptable. This fails to uphold the duty of care and competence, as it bypasses the essential step of providing informed advice based on market data. It risks misrepresenting the property's value and could lead to the client accepting an offer significantly below market value, breaching the fiduciary duty to act in the client's best interest. Another professionally unacceptable approach is to present only the highest comparable sale, regardless of its relevance or recency, to justify the seller's desired price. This is misleading and violates the principle of providing accurate and objective information. The Real Estate Agents Act requires brokers to present a balanced and realistic view of the market to their clients, not to cherry-pick data that supports a predetermined outcome. Finally, an approach that prioritizes securing a quick sale by advising the seller to accept the first offer received, even if it is below the estimated market value, is also professionally unsound. This prioritizes the broker's potential commission over the client's financial well-being and contravenes the fiduciary duty to obtain the best possible price for the client. Professionals should approach such situations by first understanding the client's objectives. Then, they must gather all relevant market data to perform a thorough CMA. This data should be presented to the client in a clear and understandable manner. Along with professional recommendations, the broker's role is to advise and guide, empowering the client to make an informed decision based on objective analysis and their own goals, rather than pushing for a specific outcome that may not be in their best financial interest. Question 18. Process analysis reveals that a client in New Brunswick has received a mortgage commitment from a lender, which includes several conditions precedent to final approval. As a real estate broker, what is the most appropriate professional action to take regarding these conditions? Option A. Directly negotiate the specific interest rate and repayment terms of the mortgage with the lender on behalf of the client. Option B. Advise the client on which specific lender offers the most competitive mortgage rates and terms based on the broker's market knowledge. Option C. Clearly explain each condition to the client. Advise them on how to fulfill them by directing them to the appropriate professionals, e.g., appraiser, insurance provider, and ensure they understand the lender's expectations without offering financial advice or guarantees. Option D. Downplay the importance of the conditions, assuring the client that they are typically a formality and will likely be met without significant effort. The correct answer is C. Clearly explain each condition to the client. Advise them on how to fulfill them by directing them to the appropriate professionals, e.g., appraiser, insurance provider, and ensure they understand the lender's expectations without offering financial advice or guarantees. Explanation. Scenario analysis. This scenario presents a professional challenge for a New Brunswick real estate broker because it involves navigating the complexities of loan underwriting and approval processes while adhering to the Real Estate Agents Act of New Brunswick and its associated regulations. The broker must ensure that their actions do not constitute the unauthorized practice of lending or advising on financial products, which falls outside the scope of their license. Misinterpreting the broker's role can lead to significant legal and ethical breaches, potentially jeopardizing their license and the client's financial well-being. Careful judgment is required to distinguish between facilitating a transaction and providing financial advice. Correct approach analysis. The best professional practice involves the broker acting as a facilitator and communicator, ensuring the client understands the lender's requirements and the terms of the mortgage commitment. This approach aligns with the broker's role as defined by the Real Estate Agents Act of New Brunswick, which permits them to assist in the negotiation and completion of real estate transactions. The broker should clearly explain the conditions outlined in the mortgage commitment, such as the need for a satisfactory appraisal or proof of insurance, and guide the client on how to fulfill these conditions by directing them to the appropriate professionals, e.g., appraiser, insurance broker. This upholds ethical standards by not overstepping professional boundaries and ensuring the client receives accurate information regarding the transaction process. Incorrect approaches analysis. One incorrect approach involves the broker actively advising the client on which specific lender offers the best mortgage rates or terms. This constitutes providing financial advice, which is outside the scope of a real estate broker's license in New Brunswick, and could be construed as the unauthorized practice of mortgage brokering or financial advising. Such actions could violate the Real Estate Agents Act and potentially lead to disciplinary action. Another unacceptable approach is for the broker to guarantee loan approval or to downplay the significance of the conditions stipulated in the mortgage commitment. This misrepresents the lender's decision-making process and the client's obligations. The broker has no authority to guarantee loan approval, and minimizing the importance of conditions can lead to the client failing to meet them, resulting in the collapse of the transaction and potential financial loss for the client. This also breaches ethical duties of honesty and transparency. A further incorrect approach is for the broker to directly negotiate the terms of the mortgage with the lender on behalf of the client beyond relaying information or clarifying standard contractual clauses. While brokers facilitate the transaction, direct negotiation of loan terms typically falls under the purview of a mortgage broker or the lender themselves. Engaging in such negotiations could be seen as practicing mortgage brokering without a license, violating the Real Estate Agents Act. Professional reasoning. Professionals in New Brunswick should adopt a decision-making framework that prioritizes adherence to the Real Estate Agents Act and its regulations. This involves clearly defining the scope of their professional responsibilities, which includes facilitating real estate transactions and communicating information between parties. When faced with situations involving financing, the broker's role is to assist the client in understanding the lender's requirements and the terms of the mortgage commitment, and to guide them on how to meet those conditions by connecting them with qualified professionals. Any action that could be interpreted as providing financial advice, guaranteeing outcomes, or engaging in activities reserved for licensed mortgage brokers or financial advisors should be avoided. Ethical conduct demands transparency, honesty, and a commitment to operating strictly within the bounds of one's license. Question 19. Implementation of a landlord's desire to end a tenancy in New Brunswick due to the tenant's persistent late rent payments. What is the most legally sound and professionally responsible course of action for a New Brunswick real estate broker to advise their landlord client? Option A. Suggest to the landlord that they inform the tenant verbally that their tenancy is terminated due to late payments and ask them to vacate within a week. Option B. Recommend that the landlord change the locks on the rental property immediately to prevent the tenant from accessing their belongings. Option C. Advise the landlord that as their representative, the broker can file the necessary eviction paperwork directly with the court without further landlord involvement. Option D. Advise the landlord to serve the tenant with a formal notice of termination, clearly stating the grounds for late rent payments and the required notice period as per the Residential Tenancies Act, New Brunswick, and to subsequently apply to the Residential Tenancies Tribunal if the tenant does not vacate. Correct answer is D. Advise the landlord to serve the tenant with a formal notice of termination, clearly stating the grounds for late rent payments and the required notice period as per the Residential Tenancies Act, New Brunswick, and to subsequently apply to the Residential Tenancies Tribunal if the tenant does not vacate. Explanation. Scenario analysis. This scenario presents a professional challenge for a New Brunswick real estate broker due to the strict legal framework governing landlord-tenant relationships and evictions in the province. The broker must navigate the Residential Tenancies Act, New Brunswick, and its associated regulations, which outline specific procedures and grounds for eviction. Failure to adhere to these procedures can lead to significant legal repercussions for both the landlord and the broker, including potential fines, loss of license, and civil liability. The broker's role as an intermediary requires a thorough understanding of these legal obligations to protect their client's interests while ensuring compliance. Correct approach analysis. The best professional practice involves advising the landlord to initiate the eviction process strictly in accordance with the Residential Tenancies Act, New Brunswick. This means the landlord must have valid legal grounds for eviction as defined by the Act, such as non-payment of rent, breach of a material term of the tenancy agreement, or the landlord's own use of the property. The landlord must then serve the tenant with the legally prescribed notice of termination, using the correct form and specifying the valid reason for termination and the required notice period. If the tenant does not vacate by the termination date, the landlord must then apply to the Residential Tenancies Tribunal for an order of possession. This approach is correct because it directly aligns with the legal requirements of the Residential Tenancies Act, New Brunswick, ensuring that the eviction process is lawful, procedurally sound, and minimizes the risk of legal challenges or invalidation of the eviction. Incorrect approach is analysis. Advising the landlord to simply ask the tenant to leave without following the formal notice and application procedures outlined in the Residential Tenancies Act, New Brunswick, is a significant regulatory failure. This informal approach bypasses the legal protections afforded to tenants and can be deemed an illegal eviction, exposing the landlord and the broker to penalties. Suggesting that the broker can directly initiate eviction proceedings on behalf of the landlord without the landlord first formally serving notice and potentially applying to the tribunal is also incorrect. The broker's role is to facilitate and advise, not to act as the primary legal authority in the eviction process. The Act clearly defines who must initiate these steps, recommending that the landlord change the locks or remove the tenant's belongings to force them out is an illegal act and a severe breach of tenant rights under New Brunswick law. Such actions constitute illegal eviction and can result in substantial legal penalties and civil claims against the landlord and the broker. Professional reasoning. Real estate professionals in New Brunswick must prioritize legal compliance and ethical conduct. When faced with a landlord seeking eviction, the professional decision-making process should involve 1. Identifying the landlord's stated reason for eviction and cross-referencing it with the valid grounds for termination as stipulated in the Residential Tenancies Act, New Brunswick. 2. Clearly explaining the legal requirements for serving notice of termination, including the correct forms, content, and notice periods. 3. Advising the landlord on the subsequent steps if the tenant does not comply, which involves applying to the Residential Tenancies Tribunal. 4. Emphasizing that any deviation from these statutory procedures can have serious legal consequences. This structured approach ensures that advice provided is legally sound and ethically responsible, protecting all parties involved and upholding the integrity of the real estate profession. Question 20. To address the challenge of accurately valuing a property in New Brunswick amidst rising interest rates, a real estate broker has gathered data on comparable sales from the past 6 months. The average sale price for similar properties was $400,000. However, the Bank of Canada has recently increased its key interest rate by 1.5%, significantly impacting mortgage affordability for potential buyers. If a typical buyer in this market could afford a mortgage payment on $450,000 at the previous interest rate, and now can only afford a payment on $400,000 at the new rate, what is the most appropriate adjustment to the property's valuation range based on this information? Option A. Adjust the valuation range downwards by approximately 11.1% to reflect the reduced buyer purchasing power, suggesting a range of $355,555 to $399,999 $999. Option B. Maintain the valuation at the average sale price of $400,000 as historical sales are the primary determinant of value. Option C. Provide a broad range of $380,000 to $420,000 without specific quantitative adjustment for interest rate impact. Option D. Increase the valuation range by 5% to account for potential seller reluctance to lower prices immediately. The correct answer is A. Adjust the valuation range downwards by approximately 1% to reflect the reduced buyer purchasing power, suggesting a range of $355,555 to $399,999. Explanation. Scenario analysis. This scenario presents a common challenge for real estate professionals in New Brunswick, accurately assessing market value in a fluctuating economic environment. The challenge lies in balancing objective data with subjective market sentiment and understanding how macroeconomic factors, like interest rate changes, directly impact buyer affordability and seller expectations. A broker must demonstrate a strong understanding of valuation principles and the ability to apply them to specific market conditions to provide sound advice to clients, thereby upholding their fiduciary duty and adhering to the Real Estate Agents Act of New Brunswick. Correct approach analysis. The best professional practice involves a comprehensive comparative market analysis, CMA, that explicitly incorporates the impact of recent interest rate hikes on buyer purchasing power and potential seller price adjustments. This approach acknowledges that while historical sales data is crucial, current economic conditions necessitate a forward-looking adjustment. By calculating the potential reduction in borrowing capacity for buyers and estimating the likely downward pressure on achievable sale prices, the broker can provide a more realistic and defensible valuation range. This aligns with the ethical obligation under the Real Estate Agents Act of New Brunswick to provide competent and diligent service, ensuring clients receive advice based on current market realities. Incorrect approach is analysis. One incorrect approach is to solely rely on the average sale price of comparable properties from the last 6 months without any adjustment for the recent interest rate increases. This fails to account for the significant shift in buyer affordability and market psychology that has occurred. The Real Estate Agents Act of New Brunswick mandates that brokers act in the best interest of their clients, which includes providing advice that reflects current market dynamics, not just historical averages. Another incorrect approach is to simply state that the market is uncertain and provide a very wide, unquantified valuation range. Acknowledging uncertainty is part of market analysis. A professional broker must still attempt to quantify the potential impact of economic factors. Failing to provide a reason, albeit potentially broad, valuation range, based on an analysis of how interest rates affect affordability, falls short of the diligence required by the Real Estate Agents Act of New Brunswick. A further incorrect approach is to base the valuation solely on the asking prices of currently listed comparable properties, ignoring recent sales data and the impact of interest rates. Asking prices reflect seller aspirations, which may not be aligned with current market realities, especially in a changing economic climate. The Real Estate Agents Act of New Brunswick requires brokers to base their advice on objective data and sound valuation principles, not just the optimistic projections of sellers. Professional reasoning. Professionals should approach valuation by first gathering all relevant comparable sales data. Then they must critically analyze current economic indicators, such as interest rate trends, inflation and employment figures, and assess their direct impact on the local real estate market. This involves understanding how changes in borrowing costs affect buyer affordability and, consequently, demand and pricing. The next step is to adjust the comparable sales data to reflect these economic influences, providing a more accurate and defensible valuation range. This systematic process ensures that client advice is grounded in both historical data and present economic realities, fulfilling professional and regulatory obligations.